When the seller fails to deliver the goods to the buyer or delay in delivery of the goods to the buyer, in that case, the buyer may claim for damages from the seller. And if the delay of the delivery cause some loss of profit to the buyer may sue for special damages for such loss of profit. Sebagai contoh, katakanlah buyer memerlukan sebuah oven baru untuk bisnes bakery yang dijalankan. Okey, akibat daripada kelewatan penghantaran oven tersebut menyebabkan buyer tidak boleh menjalankan bisnesnya dan ini menyebabkan loss of profit. So in that case, for that cost of loss of profit suffered by the buyer due to the delay of the delivery of the new oven, the buyer may sue the seller for special damages. In order to ascertain whether the goods are in good condition and there is no defect, okay, and the goods is the one which is accurate bought by the buyer, in that case, the buyer has the right to examine the goods when it is delivered to him. The third right of the buyer is specific performance. This specific performance is a kind of order or a decree from the court to the seller, that is the defendant, to continue with the contract specifically according to what has been agreed. This happened in the situation where, let's say, the buyer has bought the goods from the seller, but the seller failed to deliver or refused to deliver the goods to him. And in this situation, the buyer still wants the contract to be performed. The buyer still in needs of the good. He does not want any damages from the seller in replacing for the breach of contract by the seller. So in that case, the buyer entitled for specific performance. When the seller refuses or fails to deliver the goods to the buyer, in that case, the seller has infringed, has interfered with the right of ownership of the buyer. So in this case, the buyer may sue the seller under the law of tort, where the buyer may claim for another kind of damages under the law of tort against the seller. In the previous discussion under the topic of liabilities of sellers by virtue of the implied terms provided by the SOG 1957, there are two kinds of implied terms where we have one is implied condition and the other one is implied warranty. As for the implied warranty, if the seller breached these warranties, in that case, the buyer may sue the seller for damages.